raid and someone's response protocol. By the time enforcement arrives at the premises or issues summons, the law has already shifted from routine compliance to coercive process. At that stage, the institution's greatest risk is not only the underlying allegation, it is indisciplined response. Many matters become materially worse not because the original facts were impossible to defend, but because the response was chaotic. What are the common reasons why matters worsen? Employees panic, unverified statements are given, incomplete production of documents, destruction anxiety, backdated internal explanations, multiple people speaking inconsistently, no one being clearly in charge, no preservation of what was handed over, no discipline mode or what occurred. These are not abstract errors, they are recurring real world mistakes, and they often produce very evidentiary problems that later councils struggle to handle. So, what should happen when authorities arrive? The practical checklist begins with calm and centralization. Reception, or the first point of contact, should immediately inform the designated response team, legal compliance, and the relevant business head, the IT custodian, and external counsel where protocols so provides. The purpose is simple. One must avoid a leaderless response. The first few minutes matter disproportionately because they shape the tone and discipline of the entire event. Next, the identity and authority must be verified. One should check names, designations, department, and organization or summons, the premises mentioned, the statutory provisions involved, and the apparent scope of the action. This is not obstruction, this is basic procedural discipline. Verification of authority is entirely consistent with language. Next, cooperate but in a controlled manner. Do not obstruct physically or verbally. Do not begin threshold argument. Do not volunteer explanations beyond what is asked. Equally, do not become passive and careless. Record what is requested, what is taken, what is copied, what is sealed, and from whom. Keep an internal track. The institution's internal record of the event may later become extremely important. Next, preserve records. Once authorities arrive, no data should be deleted, altered, backdated, or informally circulated. IT should move into preservation mode, not a cleanup. This point cannot be overstated. In moments of stress, some employees think they are helping by tidying up records or clarifying old notes. In fact, they may be creating separate and grave exposure. Once action begins, preservation is the only safe direction. Next, ensure employee discipline. One nodal team should interact with the authorities. All other employees should remain available, avoid speculation, and not sign anything they have not written. This principle is absolutely vital. Institutions often suffer because 3 or 4 different people, each trying to be useful, provide overlapping but inconsistent accounts. That inconsistency then becomes the authority's strongest impression of the case. For employees, the operational rule is simple. Be courteous, truthful, but limited. Be courteous because aggression helps no one. Be truthful because falsehoods create far greater legal jeopardy. Be limited because unnecessary elaboration is dangerous. And there are also clear prohibitions. Do not guess, do not speculate, do not volunteer, do not destroy, do not discuss the matter casually on internal chat groups while events unfold. Internal chat anxiety often produces the worst documentary material because people start theorizing, admitting, speculating, or blaming and writing while the matter is lying. The section on what not to do should be treated almost like a standing wall chart in every regulated institution. Do not destroy, conceal, alter, or backfill records. Do not create retrospective explanations over email or messaging platforms once action begins. Do not permit multiple employees to give inconsistent factual narratives or make confessional or inferential statements without verifying documents. Do not hand over documents without keeping an internal record. Do not obstruct the search team. Do not assume that a casual oral clarification is harmless. In enforcement matters, there is almost no such thing as an inconsequential statement made in the heat of the moment. The statement may be later used, quoted, compared, or contextualized in a way the speaker never anticipated. So restraint is not weakness, it's legal intelligence.